So now the floor is for Dev. Dev Gangjee is the director of the Oxford Intellectual Property Research Center, and is also an associate professor of the Faculty of Law of the University of Oxford. I'm lucky because he's also a member of a GI committee. So Dev's research is focusing on intellectual property, and with a special emphasis on branding and trademarks, geographical indication, and copyright law. He's acted as advisory for national governments, international organizations, and also European Commission on IP issues. He loves contemporary dance, and he also teaches material arts. So, Dev, the floor is yours.
Thank you, Paula. And it's a pleasure to be here and a pleasure to be a part of a panel which really loves geographical indications. So Simon's throat was giving him trouble, and in the middle of it, Fernando leaned across and told me the best cough syrup for throats is tequila, with absolute authority. So if there's one thing you take away from this panel, it's that tequila can cure coughs. So with that, let's kick off. I'm going to be talking about GIs in the UK post-Brexit. And that's just a quick map of what I'm going to be speaking about, the state of play, which is well into extra time by now. And what are some of the unresolved questions in relation to national protection? I'm in an advantageous position. I can say things that both Francis and Simon can't because they're here, they have their official roles about them. So I can ask some of the difficult, awkward questions, and I'm hoping that we can pick that up later, in the questions and answers session. One of the difficult and awkward questions is what happens to EU GIs in the UK after Brexit? And that's the second issue I'll touch on. And the third is, as the UK moves away and develops its own system, will it have to match up to very strong standards of GI protection in the EU? The UK currently has passing off as the main civil remedy. Passing off doesn't go as far as EU GI law in terms of anti-evocation protection or just much stronger anti-free riding protection. So the extent to which the UK is going to need to catch up and build up its own internal system is something I'm going to look at. There are other questions which maybe we could discuss during the Q&A session, but that's for another day because I'll overshoot my time. How would the UK protect its GIs abroad? Would the UK join the Lisbon system? These are some interesting open questions. Would the UK then develop its own non-agri GI system for Harris Tweed, for example, for crafts, for textiles, and how would that look? These are open questions, but they're for another day. So let's turn to the state of play. Like Simon, I'm going to apologize to you. Many of the presentations have beautiful slides with fantastic imagery. My slides have a lot of text because they deal with a lot of law. But you are an expert professional audience of lawyers. You deal with a lot of text every day. I'm not going to apologize because that would be like apologizing for bringing a whip to a masochist's convention. You're just going to have to enjoy the pain. So let's look at the state of play at the moment. You've got the EU Withdrawal Act of 2018, and that essentially says that EU law, there's an inertial movement, and EU law carries on and is translated into UK law when Brexit happens, whenever that is. So in principle, EU law should continue to apply to the UK. In preparation for that, the UK government ran 2 consultations on establishing a homegrown UK scheme for GIs, and also on how to protect food names under that scheme in the future. And the idea was to subsequently adapt the EU system. Simon mentioned adapting the EU system. In more honest moments, people will say copy-paste with minor modifications the EU system into UK law. And that is the regulation there, the Quality Schemes, Agri-Products and Foodstuffs Regs of 2018. And some of the issues that this adaptation has had to deal with is replacing terminology. So you replace things like member state with Secretary of State. You omit member state in certain places. You have to develop a homegrown logo for UK GIs now. You can't use the PDO and PGI logos anymore, even though there's a 3-year transition period for that. You need to set up a new appeals process within the UK. So that feeds into the administrative appellate tribunal procedure, and you do that. You need to make sure that the control bodies which inspect internally within the club, that members are satisfying the GI specs. You need to tighten and enhance the responsibilities of those control bodies within the club, and then there are new enforcement measures. And largely that means under food safety regimes, you've got trading standards and food safety inspectors. they are the ex officio state machinery you're going to be using to enforce your GIs as well. So that is as far as we've got in terms of thinking about what the UK needs to do in terms of implementing the UK GI regime. And this is fairly straightforward. It's unobjectionable adaptations. The more controversial questions are, what happens to UK GIs in the EU, and what happens to EU GIs in the UK once Brexit happens? And here there is some consensus. There is a middle road, and then it sort of forks depending upon deal or no deal. So the UK clearly recognizes the economic and cultural importance of GIs. There has been a growth in food culture and appreciation of regional products in the UK over the past few decades. And visibly, you can see that food products are appreciated. So you do create a domestic regime that is WTO compliant and tries to mirror the EU system as far as possible by adapting EU legislation like Regulation 1151 of 2012. There is automatic protection for UK GIs, which were in the EU system. They automatically get registered under the UK homegrown system. What happens to the EU products, which are currently as part of the harmonized pan-European system protected in the UK today? Well, that depends on negotiations. That depends on whether there's going to be a deal or a no deal. If there is a deal, it's going to be generous to EU GIs in the UK. So Article 54.2 of the draft withdrawal agreement of the 25th of November 2018, that's the last draft, in Title 4, which deals with intellectual property, it says the basic principle of registered IP rights. So the EU TM, registered EU designs, registered EU GIs, PDOs, PGIs as well. Without any re-examination, they drop into this local UK system. They can use the UK geographical indications register. They just drop into it automatically. And then they have the same level of protection they would as they would in the EU. It's interesting to note that this is an automatic sort of transference, a creation of a new set of rights in the UK without even requiring apparently any reciprocity. So it says if the withdrawal agreement goes through, EU GIs become UK GIs, automatically get the same level of protection without necessarily saying the same should happen for UK GIs over in the EU register. So it's generous to EU GIs if there is an agreement. If there isn't an agreement, what happens? Well, one school of thought says that current EU PDOs and PGIs, which are going to be protected in the other 27 member states, will have to reapply to the UK. And that's, Francis was saying, there are about 5,000 sort of UK GIs at the moment. So potentially 5,000, or just under 5,000 reapplications to the UK system for registration. And we know in intellectual property systems, once you reapply for something, that sets off an opposition process. There's a process for trouble to sort of begin. One basis for an opposition could be the argument that the GI might be generic in the UK. And the source of that argument might be free trade negotiations with countries like the US, Canada, Australia, which do treat certain GIs in the EU as generic terms in those jurisdictions. And cheeses are the big and controversial area quite often. So we're talking about the fetas, the parmesans of this world, and that's an illustration of an American feta, which is made in Wisconsin. You can see the little logo up there. And feta is treated as generic in the US. So would the US want to export its generically labeled feta into the UK and therefore argue that feta should be treated as generic in the UK under some kind of a free trade agreement, despite the fact that feta has been a protected PDO in the UK for many, many years? Could that happen? Is rollback even possible? Well, we know what the law is. Those of us who do GIs know what the law is as it currently stands. Once your protected status is frozen and you can never become generic, you are deemed you shall not be generic once you're protected under the EU GI system. And that's the blue text up there. So unlike trademark law, where you actively have to police to prevent genericide from happening, once you're registered as a GI, you're safe. You can never become generic again. Standstill is also inferred via the EU Withdrawal Act of 2018, saying whatever EU law was pre-Brexit, that's the position which carries on post-Brexit as well. So domestic UK legislation suggests that standstill might be the default as well. And then there is the potential for EU GI users and holders who do suddenly one day find that the UK has designated them as generic to make expropriation claims saying, we had valuable intellectual property in the UK until a few months ago. You're now telling us our property's disappeared. And there is precedent for this. There's a Court of Justice decision concerning Tokai, and there was a dispute between Hungary and Italy in particular. Italy used part of the name for a grape or wine variety, and Tokaji is a protected wine appellation in Hungary. And there was a claim that once the Hungarians took over the designation, did the grape varietal users who were using it as a common name for a variety of grape, did they lose intellectual property rights? And the court in principle recognized that wine designations and things like GIs could be the basis for expropriation claims, even though in the facts of that particular case, the expropriation argument wasn't made out. So you could find arguments coming up saying, we had property, you've taken our property away, this is unauthorized and unlawful. And that would be interesting to see if it comes to that. I'm hoping it doesn't. Sometimes interesting is not good, and this is one of those situations. The final topic I want to talk about is a controversial, well, some would find it controversial one. It takes us into evocation, which is a very strong layer of protection which currently EU GIs get. And the UK would need to do quite a bit of work to upgrade its existing civil litigation remedies and options to match up to the EU standards of protection. Of course, the obvious point is the UK is already part of the harmonized EU system, and it should already have these standards in place. But in terms of civil protection, it doesn't. And you notice this because the UK has got passing off, which is a tort. And passing off is basically about misrepresentation, or lying, or cheating, or misleading the public. And evocation is about free riding, where there's a mental connection and there's a transfer of goodwill or value or benefit, even though nobody is misled or confused. So the tort of passing off has inherent limits because it's a misleading-based tort, and it can't stretch to evocation at the moment. So that's going to be interesting to see whether the UK develops that. The UK is not alone in not implementing EU standards. The EU IPO had an excellent report which came out a couple of years ago, which looked at this giant harmonized EU-wide system and found considerable variations across the member states in terms of inspection, in terms of enforcement, in terms of often the last mile of GI protection at the national level. So it's a wonderful report, only 425 odd pages, so it's a light read for the journey home, but it really sort of showcases variations within the EU regime even as it stands. So let's turn to this evocation standard and see why I'm a little concerned by it. This is what the rule looks like. It's in Article 13.1. It says, any misuse, imitation, or evocation, calling to mind, essentially, where you see one product, it brings something else to mind, and maybe that's it. Maybe nothing else sort of happens after that, is prohibited, even if qualifiers like feta-style cheese or champagne-type wine or champagne made in Australia, even if any of these qualifiers are sort of around the product labeling, that's not enough to prevent an evocation claim. So that's the rule, and these are the early cases on evocation. Cambozola is the first case that goes up to the Court of Justice asking for a clarification on the meaning of this rule. And the complainant there is Gorgonzola, and Gorgonzola says it's a similar kind of soft blue cheese, and the Zola bits are in common, so Cambozola evokes Gorgonzola, and that's where the problem is. And the court says, what does evocation mean? Well, it's a bringing to mind kind of test, like the first part of the dilution provisions in trademark law. So when the consumer is confronted with the name of the product, Cambozola here, the image triggered in her mind is that of the product whose designation is protected, Gorgonzola in this case. Does Cambozola trigger Gorgonzola? Then there is evocation, and you don't have to prove anything else. There's no likelihood of confusion required, and you do test for whether the name was consciously chosen. You do look at whether there's visual or phonetic similarity for those of you who are trademark law people. And these are the kinds of arguments you look at, but it's just a mental connection or a triggering test. And in a subsequent case concerning Parmesan, does Parmesan evoke Parmigiano? The court comes up with very similar reasoning and says, and it's an interesting case because it says even a mental connection, so it's not just visual or phonetic, but even a conceptual connection between the two is enough to trigger sort of evocation here. And that opens the doorway to subsequent cases. The purpose of evocation is not to prevent consumers from being confused. The purpose of evocation is to prevent free riding. It's as simple as that. So it's very simply to prevent parasitic competition via an association of ideas. And lots of cases sort of reiterate this. So unfair advantage of the reputation, parasitic acts, this is the core of the provision. How does that actually play out? Well, three interesting cases I'd like to talk about which test how far you can go with this mental connection kind of test. The first concerns Port Charlotte being used on whiskey, then taken to the EU IPO, and then it was OHIM, registered as a community trademark. Does the community trademark for Port Charlotte infringe the PDO for Port fortified wine from Portugal? That's really the question here. And at the heart of this case is the question of how would port be understood in Port Charlotte? Would it be understood as a place where ships park, or would it be understood as a reference to port, the fortified wine from Portugal? And the court ultimately comes down, the Advocate General and the Court of Justice have a disagreement sort of about this, and the Advocate General says that although port continues to retain connotations for a place where ships anchor, a harbor-type place, you would completely denude protection for port as a PDO if you didn't grant it strong protection. So the fact that there is this descriptive component in port still shouldn't matter, and you should just give it the same level of protection as other PDOs. So equality of protection for all PDOs is the Advocate General's argument. The Court of Justice is more nuanced and says our starting point is how would consumers see the sign, and would they make that mental connection or link? And if consumers notice port and read it in association with the name Charlotte, and they think it's a personal name associated with a place, Port Charlotte, and not an association with the wine, then it's not evocation. There is some concern that this means that port as a PDO gets very weak or modest protection, and there is some concern it'll become generic. I don't think it's going to become generic for use on the similar type of product, fortified wine, but I think there are just too many GI products. Port is used on a number of rum labels, for example. Jamaican rum uses a lot of port on it. It would be, I think the Court of Justice is right. I think the Advocate General's position was just over-generous. And I think the court said that even though you're a GI, you retain a descriptive meaning as part of your GI name, and that descriptive meaning should be accessed if that's clear to consumers. So I think that was the right decision. The next case concerns the use of a GI product as an ingredient. So you take the GI, you include it as an ingredient, here champagne sorbet, and it's a supermarket Aldi selling champagne sorbet when it uses 12% of genuine champagne in its sorbet product. And the question is this somehow parasitic competition or unfair sort of free riding, or is it just telling the truth? I sell a sorbet, the sorbet has champagne, I'm allowed to tell the world honestly what's in my product. And again, there's a nuanced answer from the Court of Justice which says, well, it depends on the kind of labeling and how you're going about making that claim. But in principle, there is nothing wrong with being honest about the fact that your ingredients contain the GI product. So they sort of reconcile this argument by saying, you are getting an advantage by using the GI name champagne in this case, but is it an unfair advantage? Well, that depends on how you use the actual label on your labeling. Big letters, 2% in the product, but it's massive, sort of 50% of your packaging kind of claiming it. It's those kinds of arguments that you look at to see whether the use is fair or not, but potentially it could be fair. And in text which is guaranteed to increase your spectacles power, so I'm not even going to try and read it, it's too small, the Commission then publishes guidelines on sort of GI ingredients, and it says, it shouldn't contain another comparable ingredient, so you shouldn't use a lot of sparkling wine in your product, 5% of champagne, and then claim it's all about the champagne in your product. You can't do that. Just because you're using 5% doesn't mean you're using it illegitimately. It may be a certain kind of truffle oil, and a very little amount is enough to give it the distinctive flavor for the product. So simple volume doesn't matter. It's how you're using it and how you're advertising it that really matters. So the Commission tries to come up with some nuanced rules on this. The third case I want to talk about is Glenn Buchenbach, which is a case concerning a German whiskey producer who is using Glenn Buchenbach as the trade name and trademark for selling whiskey in Germany. Lots of signals on the label to say that it comes from Germany, including a hunting horn, the place of production, sort of lots of clarifications that it comes from Germany. Scotch whiskey objects, and I want the trademark lawyers in the room to think about this for a moment. Scotch is the protected designation of origin. Glenn Buchenbach is the name being complained of. The two don't look anything alike. They don't sound alike. The only argument is conceptually, is there an indirect conceptual connection from Glen to Scotch whiskey to the PDO Scotch? So it's increasingly indirect mental connections and evocations which the Court of Justice is having to grapple with under the evocation sort of label. So the last point on that slide, how different can a sign be while still evoking the GI is really the question here. And again, lots of little text, so I'll just skim through it quite quickly. Evocation, the court says, is not about protecting consumers from confusion. It is about calling to mind the GI. The key requirement is that mental connection, triggering some kind of mental association. So it's based on the sort of perception of, based on the perception of consumers that's key, and it's the average European consumer. So not necessarily the German consumer who we're looking at, but the average European consumer we have to keep in mind. So while the German consumer might be sensitive to the localizing qualifications on the labeling, you have to think about how an average European consumer might nevertheless make a mental connection with Scotch. The court has relied on conceptual proximity alone in the Parmesan case. So even though they look and sound very different, is there a mental link or a connection? And it's possible to reach evocation even on the basis of that mental link or connection. We can't go too far with the mental link or association because it could start impeding the free movement of goods. It could start making life difficult for trademark owners. So there is an outer limit to evocation. But it is possible to have evocation in these sets of circumstances, and the Advocate General and Court of Justice agree. My second last slide, I'm probably going to overshoot by a minute if that's okay. The most recent case, which is only a couple of months old and comes from the Court of Justice, really it's how far the journey can be between the infringing sign and the protected designation. So our infringing sign is the cheese labeling there. It's a cheese produced in the La Mancha region of Spain. The protected PDO is Manchego, so we've got Manchego cheese, which is protected. The labeling doesn't sound like Manchego, there's no visual connection with the actual name, but the label evokes the Don Quixote books, which evokes the region which produces the PDO. So it's a four-part journey. Can that be allowed as evocation as well? So it's a long journey to the product, and the court says, yes, in principle it can, provided the immediate link from the cheese label to Don Quixote is there and not there. So if it goes down, that's evocation. If it goes up, that's not evocation. If the consumer looks at the cheese label and eventually finds their way to the region and stops, that's not evocation. But if they immediately get to the PDO as well, that is evocation. And that's the best guidance we have. I'm out of time, so I'll just leave the last slide up for questions for trademark lawyers. Evocation is stronger than even unfair advantage protection for EU trademarks. You don't have to prove a reputation. The kind of link you can prove is increasingly stretched and attenuated. Consumer perceptions vary across the EU. Trademark law tells us that. EUTM trademark law tells us that. But GI law tells us it's this one single autonomous idea of a consumer. So EU trademark law tells us, through cases like Unilever and Iron and Smith, that if you're arguing infringement in a particular jurisdiction, the trademark must have a reputation in that jurisdiction so consumers can make a link. If the mark has no reputation in that jurisdiction, they're not going to make a link. There's no harm to the functions of a trademark. EU GI law doesn't even seem to ask that set of questions. It's not asking does it mean anything to consumers here? It's not interested in that question. So it's different from trademark law. The wider evocation gets, search and clearance costs for trademark owners are going to get increasingly more challenging. So these are just some open questions which GI law has provoked for trademark law, and I welcome questions afterwards. Thank you for the extra time. Thank you.
Thank you very much, Dev, for your presentation. I guess we will have a lot of questions again. You put on the table a lot of topics. Very, very interesting topic.